Okay, so we've looked at the first of our causation videos on factual causation, and this time we're looking at causation 2, the return. And that's going to look at legal causation, the second of our 3 videos and the second of our 3 stages. So let's just have a very, very quick recap. If you recall, the first stage, or the first test, was factual causation. Did the defendant factually cause the outcome? And that's known as the but-for test. And if you recall, it acted as a filter. It sort of prevented some instances getting through to the next stage. It made it easier for us to see how many cases we should go on to continue looking at. And I've tried to make that easier for you by showing it in a simple flow chart. And what I'm going to suggest is that actually legal causation causes the largest number of problems, when technically it's quite a simple, straightforward test. And I'm going to try and break it down and make this video relatively short to demonstrate that it is a simple test to apply. The first thing that we have to do is to look and take the defendant's act and to say, did the defendant's act factually cause the outcome? And you remember we used the but-for test. But for the defendant's actions, would the outcome have occurred? And the test we use for that is R.V. White, the man who poisoned or tried to poison his mother. Mother dies of a heart attack before the poison takes effect. So he's not factually the cause of her death. The next stage, once we've shown that that's the case and the defendant has failed or passed, depending which way you phrase it, the factual causation or the but-for test, we look at legal causation. So was the defendant, or is the defendant now, having been proved to be factually the cause, are they the legal cause? And we use 2 key concepts to discuss whether or not the defendant is the legal cause. The first of those is that is the defendant's action, so is the defendant's act, a substantial and operative cause of the outcome? Is it substantial and is it operative? And I'm going to look at both of those in a moment. The second area to look at is to say it doesn't have to be the sole cause, providing that it is a cause. And what I mean by that is that it doesn't have to be the only cause of death, providing that it is one of the causes, and that cause needs to be both substantial and operative. If that's the case and we can show yes to that and yes to that, then we can say that legal causation has been shown and that we have a prohibited consequence. Now, if we can't show that, and excuse my ropey drawing, if we can imagine that that is a chain, if we can't show that both factual and legal causation are present, then what happens is we have a break in the chain of causation. So this will be the defendant's act and this will be the prohibited consequence. If we cannot show factual or legal causation, we break the chain of causation and the defendant is not liable. Okay, so with that in mind, let's take a quick look at what we mean by substantial and operative. And as is always the case, we demonstrate that by looking at some case law. And the first of these, the first that demonstrates, is R.V. Cheshire, 1991. And unlike for those of you old enough to remember, Kirsty MacColl sang a famous song called "There's a Guy Works Down the Chip Shop, Swears He's Elvis." In this instance, the defendant got into an argument in a chip shop and shot the victim. The victim was rushed to hospital and as a result of his treatment was given a tracheotomy. And for those of you who don't know, a tracheotomy is where they insert an airway into the trachea, the breathing tube, in order to allow the victim or the person on the operating table to breathe easier. Now, the defendant or the victim started to get slightly better when unfortunately what happened, he suffered some breathing problems. And the breathing problems were caused because the tracheotomy scar, which I'll just put on there, the tracheotomy scar was causing some breathing issues. The hospital should have recognised this, but they failed to do so. They were negligent, some would say even reckless, in not recognising that the likely cause of the victim's problems was the tracheotomy scar and then failed to respond to them. The defendant suggested that his actions, the shooting, were not the substantial and operative cause of the victim's death. The court, on the other hand, said that this incident, this tracheotomy scar, this breathing problem, did not break the chain of causation from the shooting. The defendant actions need not be the sole or even the main cause of death as long as they contributed significantly to that death, and the shooting was still a substantial and operating cause of the death. The man was still very ill as a result of the original shooting, and even though his death was it was in large part caused by this incident, caused by the scar, the original gunshot was still operating and still substantial. Okay. Another case to look at in this is Smith. And Smith is the case of a soldier. The defendant stabbed the victim with a bayonet during a fight in barracks. They're both soldiers. And the victim's friend took him to the first aid post, but on the way he dropped him twice. Unlucky. At the first aid post, the medical officer was busy and took some time to get to the victim, and the victim died about 2 hours after the stabbing. Had he been given the proper treatment, he would probably have recovered. So that's the background story. Of course, the defendant said, well, both dropping him on the way to the medical centre and the doctor failing to attend to him was the actual cause of death, not the stabbing. And the courts took a very different view. The courts said that the treatment he was given was thoroughly bad, and it might have even affected the chances of recovery. But whether the medical treatment was correct or not, the chain of causation is not broken. And there's a key thing that they said, which I think sums up causation brilliantly. If at the time of the death the original wound is still an operating and substantial cause, then death can be said to be a result of the wound, albeit that some other cause is also operating. So you've got two causes operating, but because the original stabbing was still an operating cause and a substantial cause, it means that the defendant is legally or has legal causation. Only when the second cause of death is so overwhelming as to make the original wound merely part of the history can it be said that death does not flow from the wound. And we'll look at a contrasting case of that in a moment. But the idea is, in short, think of it as a timeline. Okay, so think of this as time. And the idea is that if the original injury is so old that it ceases to be a threat to life, then you can say that it is part of the history and the chain will be broken. If the original injury is still operating, it's still working on the victim, and some other cause contributes to death, then the original wound, the original incident will still be seen to be both operating and substantial. So let's just break those two things down just slightly further, just to finish off. The first is, what do we actually mean by substantial? And in terms of substantial, we refer to what's known as the de minimis principle. And the de minimis principle means more than something trivial. So more than trivial. So for the defendant's act to be substantial, it needs to be more than trivial. And I've said, look, why don't we contrast a deep cut, nasty, that's a bit of a bad wound, isn't it? A deep cut and a pinprick. The pinprick can be seen to be absolutely trivial and minimal. The deep cut can be seen to be hugely serious. Yet both are classed as wounds. The pinprick is likely to fail the de minimis principle, whereas the deep cut quite obviously will pass the de minimis principle, depending on which way we look at fail and pass, obviously. So the de minimis principle says that it needs to be something more than merely trivial. And that will help us to distinguish whether or not the defendant's acts were a substantial cause of the outcome. The second thing to look at is to say, what do we mean by operative? And operative means it has to be not the sole or main, not sole or main cause, but a cause. And I'll start coming from backwards. I'll start by looking at Paget in this instance. Most of you will be familiar with Paget. What happens in Paget is, to avoid arrest, the defendant uses his pregnant girlfriend as a shield and fires at armed police. The police return fire and hit and kill the girl, unfortunately. The defendant was held to be the legal cause of death, despite causing no physical injury himself, as he set in motion a chain of events that led to the death of the girl. And it was foreseeable, if he shot at the police, that the police would shoot back at him. The court held in this case that it was the defendant's act, or the court held that the defendant's act need not be the sole cause, or even the main cause of death, providing that it is a cause in that it contributed significantly to that result. So, providing it is a cause and it is more than trivial, then we will have a substantial and operative cause. Now, the easiest way to look at this is to compare two cases where one is operative, one is not operative. We've already looked at Cheshire, and we've looked at how the tracheotomy scar did not take away from the original gunshot wound. We can compare this with Jordan. And in Jordan, the defendant stabbed the victim, and the victim died from bronchopneumonia. And he died about a week later in hospital when the original wound was healing well. Now, remember our timeline? The original injury is now healing. As it is healing, and the evidence at the trial effectively said that the bronchopneumonia was more than likely caused by the defendant's unusual reaction to a drug called terramycin. And terramycin had been given to him even after his allergy had been discovered. And it was done excessively. So the idea is that the original injury was healing and death was caused by the administration of the drug. And that happens here after. And the legal principle that falls from this is that because the medical treatment was so palpably wrong, so a good word, I think I can spell it, palpably wrong, because the medical treatment was so palpably wrong and would have precluded a jury from holding that death was caused by the defendant's actions, the chain of causation is broken. So in Cheshire, the original wound is still operating, whilst in Jordan, the original wound was healed. It was part of the history and not an operating cause. And that's pretty much it. That is as simple as you can get. That is legal causation. Remember, back over to here, that we go through the factual test first to see whether or not, but for the defendant's actions, would the outcome have occurred. If the answer to that is no, they wouldn't, they would have occurred, we then go on to look at legal causation, and we ask the question whether or not the defendant's acts is a substantial and operative cause. Is it still part of the history, and is it still part of the, is it not part of the de minimis principle, and is it operating, so is it currently in effect? And I hope that's sort of made legal causation slightly easier to understand. What we'll do in the next video is look at causation 3. If we compare it to Jaws 3 was always the worst one, so I hope this is not going to be the worst video, but causation 3, which will look at whether or not there's an intervening act which will break the chain of causation, having proved both factual and legal.